Thank you. Senator Hawley.
Thank you very much, Mr. Chairman. Mr. Chairman, it's great to have this hearing. Thanks for calling it. Thanks to all of our witnesses for being here. Professor Shaw, nice to see you again. Let me just start with you, if I could, Professor Shaw. You talked about the fact that there have been lots of rulings against the Trump administration. That's absolutely statistically true. I disagree with almost all of them. In fact, I think all of them. But the issue of this hearing really isn't the rulings, is it? It's the remedies. Would you agree? And those are distinct things. You may think that the ruling is quite correct, but that's actually not what we're talking about here today. We could have a hearing on that. Maybe we should. But we're talking today about the remedy. And the question is a remedy that binds parties who are not before the court, is that an appropriate thing? I mean, aren't you concerned about judges binding non-parties in their remedies? You may love the ruling, but even if you do, don't you think it's a little bit anomalous for courts to be going out there and binding parties who are not before them? I mean, is that something we want to encourage?
Senator, I think that judges have been issuing rulings that impact non-parties since Marbury versus Madison, right?
So you're not concerned about it?
I absolutely think that they can be abused, and
wait a minute. You were very concerned about it just a couple of years ago. Yeah. You said in response to a nationwide injunction on the Biden FDA's Mifepristone rules, and I quote, "This injunction is a travesty for principles of democracy, notions of judicial impartiality, and the rule of law."
I think I've been consistent today. That was issued by Judge Kaczmarek in a single judge division. They're a problem. Those are a problem.
Personally? Wait, no. Your testimony is if it's issued by Judge Kaczmarek, it's bad?
No, sir.
It's personal?
That is not my testimony.
So is the problem with the injunction? You were criticizing the universal injunction
issued by a judge in a single judge division. I've been very clear today that those are a problem.
By a Republican judge in a Republican division, then it's bad.
No, Senator.
Otherwise, it's fine.
No, Senator. I think that single judge divisions are a problem.
What is the principal difference? I'm looking for a principle. I understand you hate the president. I understand you love all of these rulings against him. You and I both know that's not a principle. You're a lawyer. What's the principle that divides when issuing a nationwide injunction is okay when it's not? When the Biden administration was subject to nationwide injunctions, you said that they were travesties for the principle of democracy. You didn't say the referral to Judge Kaczmarek was a travesty. You said his injunction was a travesty for principles of democracy. So, in other words, the translation is just you didn't like the outcome. Is that right?
No, Senator. Look, we're talking about, I don't think Article 3 precludes this form of relief. So we are talking about prudential consideration.
Prudential meaning political?
No.
Then give me, so far I have yet to hear it. You've been questioned by multiple senators. I have yet to hear a principle other than the fact when you like the ruling, you think it's great to apply it nationally, including non-parties. When you don't like the ruling, it is a travesty for the principles of democracy, notions of judicial impartiality, and the rule of law.
Look, Senator, I'll say, I think I am self-aware enough to know that my view of the underlying legal question, I am sure colors my perception of the remedy. I think that we should all acknowledge that. And yet I do think
why shouldn't we stop nationwide injunctions for everybody?
I think
that's what we're talking about today.
Because I'm not willing to leave without relief non-parties who are
you're not willing to leave without the ability to bind President Trump.
No, I
right?
think that...
I mean, when it's Biden, it's okay. No. When it's Biden, it's a travesty. When it's Trump in office, it's no holds barred, whatever it takes, right?
I believe in a powerful...
What was it that President Biden's staff said? We've got to do undemocratic, unconstitutional things to save democracy.
I believe in a powerful president. I do believe in presidential power, but power and constraint are not at fundamental odds.
What is the principle? What is the principle? The legal principle. You've referenced prudence. You've referenced the judges you don't like. What's the principle of when an injunction binding non-parties, which was never done in this country before the 1960s? And let's see the chart, the Trump chart, which was done really only once Trump came into office for the first time. Now, you don't think this is a little bit anomalous? You don't think that's a little bit strange?
A very plausible explanation, Senator, you have to consider is that he is engaged in much more lawless activity than other presidents, right?
You don't think this was never used before the 1960s, and suddenly Democrat judges decide we love the nationwide injunction, and then when Biden comes to office, no.
It's Republican appointees as well, Senator, and the 1960s is where some scholars locate the beginning of this, but others, Mila Sahoni, who's another scholar of universal injunction, suggests 1913 is actually the first, others in the 20s.
The Republican endured for 150 years before the nationwide injunction.
Well, the federal government was doing a lot less until 100 years ago. So there's many things that have changed in the last 100 or the last 50 years.
So long as it is a Democrat president in office, then we should have no nationwide injunctions. If it's a Republican president, then this is absolutely fine, warranted, and called for. How can our system of law survive on those principles, Professor?
I think a system in which there are no meaningful constraints on the president is a very dangerous system of law.
That's not what you thought when Joe Biden. That is not what you thought when Joe Biden was president. You said that is not what you said. You said it was a travesty for the principles of democracy, notions of judicial impartiality, and the rule of law. You also said when Joe Biden was president. You also said when Joe Biden was president. You said the idea that anyone would foreign shop to get a judge who would issue a nationwide injunction was just politicians, just judges looking like politicians in robes. Again, it threatened the underlying legal system. People just trying to get the result they wanted. It was a travesty for the rule of law. But you're fine with all of that if it's getting the result that you want.
Sir, the Supreme Court agreed unanimously with me in that case, right? There was no standing. The case should never have been allowed to proceed. And the combination of parties without standing and the single judge division.
No. We're talking, no, they did not. They did not issue a ruling on the nationwide injunction. You criticized the injunction nationwide. Listen,
issued in a case where no one had standing.
Here's the thing. We've now gone 6 minutes, and Senator Kennedy had you for 6 or 7. You couldn't identify a single principled basis. We all know the truth here, which is it's not just you. It's most of my colleagues over here on this side of the aisle, who I respect a great deal, and they were raising very principled objections to the nationwide injunction just 6 months ago, maybe 9 now. And you're probably right. My point is that all that's changed in 9 months is the occupant of 1600 Pennsylvania Avenue. And I realize that my colleagues on this side of the aisle very much dislike that individual, and I realize that you think that the rulings that he has lost are fundamentally sound. We might grant all that. I disagree with all of that, but we can put that to one side. The question we're talking about here is, should judges, single judges, district court judges, be able to bind non-parties who are not in front of them? And you used to say no, now you say yes. Let's be consistent. I would just suggest to you our system of government cannot survive if it's going to be politics all the way down. Thank you, Mr. Chairman.
Can I briefly respond?
Sure.
I mean, you invoked democracy a couple of times there, Senator. Judges are part of our system of democracy. Democracy is not as simple as majority rule. Judges have always served something of a
You would have it be as simple as majority rule. When you get the majority you like, you're for the nationwide injunction. When you don't, you're not.
Senator Blumenthal.
Thank you, Mr. Chairman. I'm going to give you the opportunity that I often found absolutely precious when I was arguing before panel judges and couldn't get my answer.
The hearing room had grown tense long before Senator Josh Hawley uttered the words that froze it in silence. I understand you hate the president. It wasn't just an accusation. It was a spark, igniting a moral and political divide that reached far beyond the mahogany desks and microphones of Capitol Hill. Before him sat Professor Shaw, a constitutional scholar, calm on the surface, but cornered beneath the senator's relentless cross-examination. What began as a debate over injunctions, the power of a single judge to halt federal policy, quickly became something far more human. It became about bias, about motive, about truth itself, in an era when every principle seems to bend toward partisanship. Hawley's words sliced through the formality. You love rulings against him. You hate the president. But that's not a principle. That's politics. The echo of that sentence lingers because in it lies the question haunting modern America. When law and ideology intertwine, who speaks for justice? For nearly a century, the nationwide injunction has been a rare, extraordinary power, allowing one federal judge to bind the entire nation with a single ruling. Once it was invoked sparingly, seen as a safeguard against executive overreach. But in recent years, it has become a weapon, wielded not for justice, but for vengeance, used by both sides, abused by both sides, and defended only when convenient. Hawley, sharp and prosecutorial, drove that point home with the precision of a man on cross-examination. He read Professor Shaw's own words back to him, quotes from just months earlier, when the professor had condemned a Republican-appointed judge's ruling against the Biden administration as a travesty for democracy. Now the same man defended the same judicial power, only this time when it was used against Donald Trump. The exchange became a mirror, reflecting what happens when conviction gives way to tribal loyalty. Hawley's voice rose, deliberate and cold. When it's Biden, it's a travesty. When it's Trump, it's whatever it takes. And there it was, the hypocrisy of Washington, laid bare under oath. In that instant, the hearing stopped being about injunctions. It became about America's soul, about whether our leaders, our scholars, our courts can still tell the difference between principle and preference. Professor Shaw tried to respond, to nuance the argument, to suggest that context mattered. But Hawley's point had already landed. All that's changed in 9 months, he said, is the occupant of 1600 Pennsylvania Avenue. The meaning was unmistakable. The rules don't change. The players do. And when they do, justice bends like metal under heat. It is the same pattern that has defined this era, where every principle of governance is tested not by what is right, but by who benefits. When a Democrat wields power, Republicans cry tyranny. When a Republican wields power, Democrats cry fascism. Both sides insist they are defending democracy, and both have forgotten what democracy truly means. The founding promise of checks and balances was not designed to protect parties. It was designed to protect people. But in hearings like this one, the law becomes spectacle, and truth becomes sport. What Hawley exposed, or at least forced the nation to confront, is a reality too many have grown numb to, that our judicial debates, our moral arguments, our academic defenses have all become instruments of partisanship. The professor's struggle to articulate a consistent standard wasn't just a personal falter. It was symbolic of a system that no longer knows how to think in absolutes. Everything is conditional, every value negotiable. And yet, for all his ferocity, Hawley's own motives are not immune to question. He, too, operates in a theater of politics, a stage where outrage is currency and moral authority is weaponized. His interrogation, though pointed, was also performance. Every syllable aimed not just at the witness before him, but at the cameras, at the headlines, at the voters who crave a champion against hypocrisy. That is the tragedy of modern America. Even when truth is spoken, it arrives dressed as strategy. Still, amidst the clash of intellect and ideology, one truth shone through the noise, that justice cannot survive if it depends on who occupies the White House. The rule of law, once compromised by convenience, ceases to be law at all. Hawley's final words carried that warning, though few seemed to hear it. Our system of government cannot survive if it's politics all the way down. A statement that, in its simplicity, reveals the rot beneath our republic. Because that is exactly what we have become. Politics all the way down. From the courtroom to the classroom, from the newsroom to the Senate floor. The Constitution was built on faith, not faith in parties, but in principle. It assumed that men and women entrusted with power would at least attempt to rise above themselves. But on this day, in this hearing, that faith felt fragile. When a professor of law admits that his legal reasoning is colored by political sympathy and a senator uses truth as a cudgel rather than a compass, the audience is left to ask, where then does justice live? Perhaps it lives in the uncomfortable silence that followed, the moment after the gavel struck, when the cameras panned away and the audience exhaled. Because in that silence, stripped of applause and argument, the question remained. What happens to a democracy when every principle becomes negotiable? When the left and right trade moral outrage like currency, and the pursuit of truth becomes just another partisan sport? The answer is what we saw in that room. A government that no longer governs, but performs. A nation where truth is relative and justice, like power, belongs to whoever shouts loudest. But even in that decay, there is hope. Because awareness is the beginning of change. When citizens see hypocrisy not as entertainment but as warning, when they demand integrity from those who speak in their name, democracy breathes again. This hearing was more than theater. It was revelation. A moment when the mask slipped and the nation saw what politics has made of principle. And it is now up to us, not senators, not professors, not judges, to decide whether that is acceptable. Because democracy, in the end, is not just what happens in the halls of power. It is what happens when ordinary people choose truth over tribe. This is liberal freedom. Subscribe, stand with us, and never stop demanding integrity before it disappears entirely.